Hi guys, it's Kathy. I hope you're doing well. I'm very confused right now. 12 years of Catholic school, and I'll admit that's not my thing anymore at all, but I thought I understood what the word saint meant. Let's just watch an arson trial. Let's do that.
3 of the trial, State of Indiana versus Christopher Williams, 20C01 2501 F43. I have in court for the State of Indiana Deputy Prosecuting Attorney Don Pitzer and Deputy Prosecuting Attorney Kathleen Clays. I have for the defense the defendant Christopher Williams in person by his attorney Jeffrey Majerick. When we recessed last evening, we talked off the record about what we needed to get done this morning before we bring it to Mr. Majerick, first, has your client decided whether he will or will not testify?
He's decided he will not.
Is that correct, Mr. Williams?
Yes, sir.
Darn it, I wanted to hear him.
Now, as I have advised you at least twice, it's probably been more than that. I need to make a record on that. I'm going to ask you certain questions. You'll answer those questions. If there's anything else you want to say, I'm going to let you say that also, but you'll answer those questions. I'll then ask Mr. Majerick and Mr. Pitzer if they've got any record they want to make. The record I'm making, I want to be clear. The record I'm making is that this is your own voluntary decision not to testify. Do you understand that?
Yes, Your Honor.
So let's start with this. Under the U.S. Constitution and the Indiana State Constitution, you have an absolute right to testify. Do you understand that?
Yes, Your Honor.
In other words, you can be sworn in front of the jury, take the witness stand, and answer questions just like every other witness has in this case. Do you understand that?
Yes, Your Honor.
That gives you the opportunity to tell your story. Do you understand that?
Yes, Your Honor.
It may be an advantage to you to do that. Do you understand that?
Yes, Your Honor.
There's also a risk involved. Do you understand that?
Yes, Your Honor.
So if you take the stand and you start to testify and it starts to go horribly wrong, you don't get to raise your hand and say, Judge, I've had enough. I'm done testifying. Do you understand?
Yes, Your Honor.
In other words, once you start testifying, you have to complete your testimony. Do you understand that?
Yes, Your Honor.
By that I mean, it's not just direct examination by Mr. Majerick, it's cross-examination by one of the deputy prosecuting attorneys. Do you understand that?
Yes, Your Honor.
I think it is unfortunate that you have not seen either of these deputy prosecuting attorneys do a very zealous cross-examination. So you will have to just imagine what that would be like. But you will be cross-examined thoroughly and zealously if you testify. Do you understand that?
Yes, Your Honor.
Let's turn over to the other side. Under the U.S. Constitution and the Constitution of the State of Indiana, you have an absolute right to remain silent. Do you understand that?
Yes, Your Honor.
In other words, Mr. Williams, I can't make you testify. Mr. Majerick can't make you testify. The prosecuting attorney can't make you testify. The state of Indiana can't make you testify. Law enforcement can't make you testify. Do you understand that?
Yes, Your Honor.
You can exercise that right, and then your case concludes without you testifying. Do you understand that?
Yes, Your Honor.
Now, while you don't take the stand and tell your side of the story, your side of the story may have been told by other witnesses. Do you understand that?
Yes, Your Honor.
Have you considered all of that in reaching your decision not to testify?
Yes, Your Honor.
I don't want you to tell me what you and Mr. Majerick talked about. I only want to know this. Did you have an opportunity to discuss with Mr. Majerick whether you should or should not testify?
Yes, Your Honor.
Did you have enough time to do that?
Yes, Your Honor.
I need to know this, Mr. Williams. Is it your own decision not to testify?
Yes, Your Honor.
You're not being forced by anybody not to testify, correct?
No, Your Honor.
Let me ask it another way. Are you being forced by anybody not to testify?
No, Your Honor.
Nobody's threatening any of your family, friends, or a loved one in order to get you not to testify.
No, Your Honor.
Let me ask it another way. Is anybody threatening your family, your friends, or a loved one to get you to testify?
No, Your Honor.
Mr. Williams, you can tell I'm a judge and not an attorney. I forgot how to ask questions. Are you under the influence of alcohol or any drugs at this time?
No, Your Honor.
Is this your own decision?
Yes, Your Honor.
Are you making it voluntarily and of your own free will?
Yes, Your Honor.
Are you telling the court that you think it would be in your best interest if you did not testify in this case?
Yes, Your Honor.
Mr. Williams, do you want to testify on your own behalf in this case?
No, Your Honor.
Mr. Williams, is there anything else you want to tell me with regard to your decision not to testify?
Yes, Your Honor.
Go ahead.
I felt like, honestly, Your Honor, I already denied that I didn't light this fire and I didn't do it. And this is the reason why we're here. We're here because we have testimonies and statements saying that I did it and we heard it. So I honestly don't feel like there's anything more for me to say.
Very well. Mr. Majeric, any additional record you want to make on this?
No, Your Honor.
Mr. Pitzer, any additional record you want to make on this?
No, with just the comment, as the court no doubt is aware, we want to pull the instruction on did testify.
Pardon?
At the appropriate time, we'll want to pull the instruction that says did testify.
That's coming up. That's coming up next. I'm not bringing the jury until we get jury instructions done. Okay? Mr. Williams, thank you for your testimony. Thank you for making the record. I do that for every defendant, whether they testify or not. Okay, now, counsel, let's turn to jury instructions as proposed by the court and a verdict form. Do you get to see the verdict form?
Yes.
Yes, Your Honor.
State of Indiana, is the verdict form acceptable?
Yes.
Mr. Majeric, verdict form acceptable?
Yes, Your Honor.
May I show that it's given by agreement of the parties, Ms. Clays?
Yes.
Mr. Majeric?
Yes, Your Honor.
Okay, let's turn to the proposed final jury instructions, please. I have not numbered these yet. I want to be clear. I went through these last night. I rearranged the order. Good morning, ladies and gentlemen of the jury.
Good morning.
Welcome back for day 3 of the trial. When we recessed last night, the state of Indiana was in the midst of its case in chief and presentation of testimony and evidence to you. That will continue this morning. Mr. Pitzer?
Thank you, Your Honor. At this time, the state rests.
Thank you. Ladies and gentlemen of the jury, I will now invite Mr. Majeric to present testimony and evidence if he decides to do so. I remind you, the defendant is not required to present any testimony or any evidence to prove anything. The burden is on the state of Indiana. Mr. Majeric,
Oh,
proceed,
yes,
please.
that's hers. Yeah.
Thank you, Your Honor. And the defense rests.
Damn, Monica. Leave some men for the rest of us, will ya? Come on.
Ladies and gentlemen of the jury, that concludes the evidentiary portion of the trial. I will now invite the attorneys to make closing arguments or final arguments to you. I remind you that final arguments are not evidence. They are just what I said, arguments. The attorneys will oftentimes try to persuade you and characterize the evidence as they want you to see it. Because the state of Indiana has the burden of proof, the state of Indiana will be allowed to go first and last. State of Indiana, Ms. Clays.
Thank you, Your Honor. Jess, is the screen on? Thank you. Thank you to the court and counsel. Anger, threats, arson. On September 8th of 2024, this defendant, Christopher Williams, was angry. We have learned throughout the course of the trial possible reasons why he was so angry. Perhaps his relationship goals with Chelsea were not being met. Perhaps his friendship expectations with her, knowing where she was, knowing who she was with, why she wasn't home, weren't being fulfilled. Maybe he was just pissed off that he was getting kicked out of the house. Whatever the reason, we know that on September 8th of 2024 in the evening, this defendant went to 712 North Hawthorne here in Elkhart County, where there were several kids in the house, armed with a handgun, aggressive, and this defendant started making threats. If your mom is not home in time, I'm going to shoot her. If your mom is not home in time, I'm going to burn this bitch down. I'm going to burn this motherfucker down. If your mom is not home in time, I'm going to shoot you. If your mom doesn't come home or if anyone leaves, you're going to get shot. Specifically to Caden, and I wrote this down when he testified, if you think y'all going to leave, my cousin in a bush will shoot y'all. To teenagers, to children, mad enough, aggressive enough, angry enough, that when the defendant left the house and these kids realized that their home was no longer a safe place, these kids took off running and hid in a tree line outside because they were so scared. And why wasn't their home a safe place? Because this defendant left a parting gift. He went into that back bathroom and he lit a pile of clothes and a bunch of plastic on fire. And then he closed and locked the bathroom door. He closed and locked the bedroom door, and he fled. He took off and he left 3 kids, whether they were inside when he left or outside, in a space that was literally going to go up in flames. Anger, threats, arson. Back on Monday, the state spent a lot of time with all of you on the charging in this case. And we talked a lot about the elements, the building blocks, the ingredients, whatever you want to call them, that the state had to prove beyond a reasonable doubt to find the defendant guilty. And Mr. Pitzer told you in opening statement that throughout the course of the trial, it was the state's intention to provide you with enough evidence, enough information, so that you could believe beyond any reasonable doubt that the state had met their burden in each one of those elements. And I submit to you on behalf of the state that we have done that. So let's talk about those charges a little bit. I'm going to go in reverse order. We're going to start with the intimidation. So what we have to prove is that the defendant communicated a threat, we all know what a threat is, with intent that another person be placed in fear that the threat would be carried out and the threat was to commit a forcible felony. So the way that this lays out in the charging information is that Caden is the victim. Caden is the person that the threat was communicated to. Caden was the person that the defendant intended to place in fear. There's been a lot of other testimony that he threatened Gabby, he threatened Trey. There were lots of things being said, but at the end of the day, Caden's the victim. The threat was to commit a forcible felony. So a forcible felony is something that essentially puts people in danger, bodily injury, serious crime. Arson. Defendant, by means of fire, explosive, or destructive device, knowingly damages a dwelling of another person without that person's consent. So we've got Chelsea, she's the homeowner, her home is damaged. Let's go back to the intimidation for just a second. When you're thinking about the intimidation, I just read to you the specific threat of a forcible felony that was said to Caden. This is what he said during his testimony. If you think y'all gonna leave, my cousin in a bush will shoot you. Mr. Pitzer told you in opening statement that that was one of the things that was said to these kids. So the state has proven each one of these elements that Caden was communicated a threat by the defendant, that Caden obviously was in fear of that threat because he went outside of the house at least a couple of times and then ended up hiding in a tree line. And the threat was to commit a forcible felony. I'm going to shoot you. I'm going to shoot y'all. So for the arson, we know from the fire investigator, Tanner O'Brien, Thomas O'Brien, however you want to refer to him, that this fire took place based upon fire, explosive, or destructive device. So he told you that the ignition sequence was essentially a flame, a lighter, a blowtorch, not a vape, something that emitted a flame. There was damage to Chelsea's house, and she certainly did not consent to this fire being lit in her house. So what are we left with? The defendant, right? And that he did this knowingly. So it wasn't an accident. It wasn't a fluke of nature, any of those kind of things. So from the state's perspective, if you believe those kids, if you believe Trey and you believe Caden, including not only their testimony here, but the statements that they've previously given to law enforcement, to fire, that other people came in and testified about, the state has met its burden for both of those charges. Here's why you should believe them. Let's talk a little bit about evidence that is independent of Trey and Caden's version of events, but they help to corroborate what Trey and Caden have said. So we're going to start with the timeline. We know the defendant was at the house around the time that the fire started. And we know this for a couple different reasons. Officer Miller Coral gets called out to that location sometime in the 9:30s on September 8th of 2024. There's a noise complaint. He testified that he gets to the location at about 9:45. There is a black SUV in the driveway. We have shored up time and time again that the black SUV is being driven by Christopher Williams. It belongs to his mother. He was driving it. He had access to it on a regular basis in September of 2024. We know that because Detective Laux followed up with Christopher Williams' mother, and she said, yeah, that's my vehicle. He drives it. He has it. The vehicle is there for at least 2 other pass-throughs that Officer Miller Coral does up until he clears that call at 10 p.m. Remember that the 911 call comes in at 10:16 p.m. Officer Miller Coral also corroborates what Trey and Caden tell you about the defendant moving stuff out of the house. If you remember, Officer Miller Coral said every time that he passed the vehicle, there was nobody in it. He didn't see anybody, but that the passenger side door of the car was open on each occasion. That corroborates this defendant likely moving stuff out of that house and putting it into that SUV. We know that the defendant left the house just a few minutes before the 911 call took place. And we know that because he was picked up on the flock camera at the Michigan state line at 10:32 p.m. And Mr. Majerick can get up here and make whatever hay he wants to out of this Google Maps estimate, but Detective Laux was very clear that based on driving conditions, traffic patterns, speed, all kinds of different variables, it is not unreasonable to believe that this defendant got from 712 North Hawthorne all the way up to the state line in 15 to 20 minutes. You have to remember, it's a Sunday night, it's past 10 o'clock. The likelihood that these roadways are going to be super well traveled by other people is unlikely. So then the 911 call is made. And Caden testified yesterday, and he's told law enforcement all along that he called 911 when he got out of the house and when he made sure that his friends were safe. This took several minutes. Think back to all the things that he told you happened. And again, whether you believe that these kids were outside or they were inside when the defendant left, think about the facts that he told you. So, and Trey for that matter,
Hi, Beth.
there's a smell in the house when the defendant leaves. The boys are looking through the house trying to figure out what smells like that. They can't figure it out. The smell gets stronger. So they're like, okay, we need to keep looking for whatever this is. They get to the bedroom door. It's locked. They have to jimmy it. They get to the bathroom door. It's locked. They have to jimmy it. Oh my God, the house is on fire. Let's try to put this out. They take some sort of big stew pot, like 14 and 19-year-old boys would do, and try to fill it with this little faucet. You can see it in one of the photos, this tiny faucet with water. And then somewhere in there, they're like, oh man, this isn't going to work. We've got to get out of the house. And oh, by the way, my 14-year-old brain is telling me that I need my PlayStation and I need my clothes. So this takes a good amount of time for the fire to be started, for them to realize that it's happening, to get out of the house, to try to put it out, whatever, and then to call 911. All of this lines up. All of this timeline lines up. And because it lines up, there is zero opportunity after this defendant leaves for these kids to go into this bathroom and start a fire. And then do all these things, which they both talk about, and Mr. Majerick didn't really make any headway on cross-examination about all these things that they both said that happened within the house in this time. Trey testified yesterday that the defendant had been in the house for at least 20 minutes over the course of the time that he was there. And I think he testified on cross-examination that it could have been 20 minutes, 30 minutes, 40 minutes. It probably felt like a very short period of time because of everything that was happening. But we know from the officer that passed through this park that the defendant was there when he got there at 9:45 and he was there when he left at 10. He's taking big stuff out of the house. He's taking all of his clothes. He's taking these speakers and amplifier, which Mr. Majerick made it a point yesterday to point out how large these things are, how heavy they must be.
Emily has.
He's got grow tents, which I don't even know what that is, but they seem to be substantially large. So he's having to take some time to get these things out of the house, probably one by one, because these kids sure aren't helping him. He's got stuff piled up by the laundry room. He's got stuff piled up in Chelsea's room. There is no indication in any of the evidence that these kids were anywhere near Chelsea's room when the defendant was coming and going and moving around the house. By the time he left, probably a little after 10 p.m., it is completely unreasonable based on the timeline to believe that any of these kids went into that bathroom and started that fire. So I talked a little bit about with these elements that if you believe these boys, the state has met its burden on both these charges. But my guess is, I've been doing this a long time, my guess is some of you are not completely convinced at this point, and that's fine. So let's talk about Chelsea, Caden, and Trey, because their credibility really is the crux of this case. And I want to start here. For the next few minutes, I want you to just
He goes
humor
with
me.
you. Bye, Bobby. He goes with
And
you.
I want your brain to just automatically believe them. Say, I believe them. And I want you to think about that while I go through this. I'm 14 years old. I'm 19 years old. I'm at home with my friends, screwing around, playing on the PlayStation, listening to music, hanging out with the dog. My mom is gone. A man that I barely know comes to the door. He's pissed at my mom. He's walking around with a handgun. He's yelling. He's talking about how he's going to shoot people and burn my house down. Should I believe him? Should I not believe him? Where is my mom? I'm 14 years old. I'm 19 years old. Then this dude leaves. And at some point, I realized that my home, my safe place, where all of my teenage prized possessions exist in this space, is on fire and is likely going to burn to the ground. I can't save it. My teenage brain is in panic mode. I try to put it out. I can't put it out. Oh my God, I'm going to lose all my stuff, lose all my electronics, lose everything that I own. Get it out. Get out as much as you can. My mom is not home. Now I'm outside. Where am I supposed to go? Is someone out here waiting to shoot me? Is someone out here waiting to shoot my mom? I need to call someone. I'm 14 years old. I'm 19 years old. I'm scared. I'm going to go hide in these trees. I need to call 911. Are my friends safe? Am I safe? Is this dude going to come back while I'm out here? Now the police are here. Now the fire department is here. There are bright lights and oxygen masks and fire hoses. My mom comes home. I can see my mom. I need to get to my mom. There are people asking me questions. I don't know these people. I don't know who they work for. I'm 14 years old. I'm 19 years old. I asked you to kind of engage in that, just assuming that you believe Trey and Caden, and you can do the same thing with Chelsea. I'm a mom. I'm not home. I'm getting called, that my house is on fire. I've been in this fight with this dude all day long. I thought things had kind of cooled down. Where are my kids? I get home. There's no one there. Are they dead? Are they shot? Did he follow through with what he said he was going to do? My house is on fire. I have nowhere to live. You can go back and do the same analysis with her. The reason that I'm asking you to do that is because I anticipate, as is his job, that Mr. Majerick will get up here and make a lot of hay, I guess, out of, hey, these people didn't say the most important things the night of the fire. Hey, even a couple of days later, these people didn't say exactly the same thing, or they added something, or their stories aren't consistent across the board. This person said bitch. This person said motherfucker. This person didn't mention a gun. These people are in absolute panic mode. They are in survival mode. They are standing in their front yard watching literally everything they own. All of the hard work to own this home, all of the work it took to bring things into the home, to find furniture, to bring their clothes over there. It's literally going up in flames. And then the expectation somehow is that they're going to worry about the whodunit. There's also law enforcement and fire that are running around all over the place. We listened to Assistant Chief Haynes yesterday talk about it's about safety. Safety of the people who are at the scene, safety of the law enforcement, safety of my fire guys. And then everything else kind of comes next. So they've got people who are coming back and forth and asking a question here, a question there. Sometimes 4 or 5 questions, while you're literally watching your life burn before your eyes. They're answering the questions that are being asked of them while they're trying to figure out, where am I going to get clothes from? Where am I going to sleep tonight? Where is my next meal going to come from? After all of the other trauma that they've just experienced. But you know what? The interesting thing is that these people do stay and they do answer questions. Chelsea stayed basically until the very end when the fire was out and they locked her house up. They gave their names, they gave their dates of birth, they gave their phone numbers. They gave whatever identifying information the officers needed for them to be found. They gave basic information kind of about what had gone on in the last 45 minutes. And then when they got it together a little bit over the course of several days, they do meet with law enforcement. Chelsea does meet with the fire investigator. I think Hayden and Chelsea both talked about how even over the next several days, there was a lot going on. They were put up in hotels. They were moving from hotel to hotel. Chelsea said, we left with the stuff on our backs, but they had the wherewithal to get up and go to the Elkhart County Sheriff's Office on their own. It wasn't even a set-up interview. They went, they were interviewed, it was recorded, they were asked questions. They did talk, Caden and Trey both did talk about the gun being present and that if she's not home in 10 minutes, one says one word, one says the other. One says it's 15, one says it's 10. If you think about it in a different way, you guys have all sat here for 2.5 days now. And in the course of that time, I've worn some different outfits. I've asked different questions of different witnesses. I've gotten up and moved back and forth. I filled my water glass. And I can almost bet money that when this is all over and somebody asks each one of you individually, what was she wearing? What questions were asked and what was the answer? How many times did she refill her water glass? How many times did she go up to the bench to talk to the judge with Mr. Majerick? I can almost bet money that every single one of you would remember things differently. But at the end of the day, you would all be able to say, she wore dresses, she questioned people, she refilled her water cup, and she sat back up and down. Those are the basic facts. And hopefully, this is not a traumatic event for all of you. So add that on top of it. These are all things that you all can consider when you are thinking about credibility. Do I believe these people? They went and talked to law enforcement. So did Chelsea. And she was adamant with Mr. Majerick when he kept asking her, well, you didn't tell anybody about these fights. You didn't tell anybody about this gun. You didn't tell anybody about this. And she kept saying, I know I told somebody. I talked to maybe 40 or 50 people over the course of several days, but I know I told somebody. And you know what? She did. And that's why at the end of my direct, I asked Investigator O'Brien about that. And there are rules that we have to play by in this courtroom where I can't ask him certain things. I can't ask him what did Chelsea...
approach.
If only someone would have cut out this long pause.
Ladies and gentlemen, jury, Mr. Majuric lodged an objection to the last statement made by Ms. Clays. That objection will be sustained. Ms. Clays is going to go on with her closing argument.
Thank you. She did talk to him. He told you, she provided me information. I got to see some text messages. She was being honest with Mr. Majuric when she was adamant. I did meet with the fire and I met with somebody. I know I told somebody these things. But the expectation here somewhere is that in all of this chaos and trauma and tumultuousness, that the story is the same every single time, and I'm going to tell every single person my story. That's not reality, and that's not reasonable. That's not the way that this works. And then these people came in here after a year and a half. Every single one of them, Kaden, Trey, and Chelsea, they came in here and they sat in that witness chair and they talked to 14 people that they don't know. Trey is 15 years old. Kaden is 20 years old. Think about whether or not they've had experience talking to people on a regular basis like all of you, and how much of a struggle that must have been. But they did it. And they were consistent with their participation all the time until now there is a resolution. Those are all things that you can consider when you decide whether or not you believe these people. And the state submits to you that we have, beyond any reasonable doubt, proven through those people that this defendant started that fire. When we talk about knowingly, this fire was not an accident. And we know that first and foremost because the defendant told them that he told these kids what he was going to do. I'm going to burn this house to the ground. And he followed through with it. He went into that back bathroom . He took out some sort of lighter, some sort of flame, and he lit that pile of clothes on fire. You heard the fire investigator tell you the water wasn't going to make it more difficult to figure this out. It couldn't have been a vape because that's not considered an independent flame source. It had to be started by a person with a flame source. That's not an accident. That is knowing conduct. And then knowing that there were 3 kids in the house, he closed and locked that bathroom door, he closed and locked that bedroom door, and he took off. Angry, threats, arson, guilty. Thank you.
Thank you, Ms. Clays.
Thank you, Ms. Clays.
Mr. Pitzer?
Mr. Majuric?
No, Mr.
Defense,
Pitzer.
please.
Thank you, Your Honor. Morning, ladies and gentlemen. Oh, it's, I would say, a long 3 day. Same 24 hours, but it seemed like they're longer each and every day. All right. So over the 3 days, we were supposed to believe that we had this torrid, rage-inducing friends with benefits relationship. Folks, he was either at some point when asked to get his stuff out of the house, he was coming after us with a gun, or as she pointed out to investigators, he was fine, he was calm, I wasn't worried about him. How worried was she that he was coming after her with a gun? He had a gun, he was coming after us. Go to my house where my kids are alone and get your stuff. Yeah. Then you come back later in the day, in that evening, and you arrive and your house is on fire. And what do you tell Schuster? He was cool. I'm on the phone. He was cool. He was angry, Not he was yelling, not that he was mad, not at that point did she say he was coming with a gun,
I can handle that earworm. That's a pretty good one.
or he was coming with a gun. We had a gun, we went and put it up. None of that. It was, he was cool. I thought this was gonna go well. They went off and I think I took her to the cousins on Con, and she said, yeah, that's where we were going. No mention of the gun. Chelsea also said from the time Chris was on his way, texted her, said, I'm on my way, gonna be there if you, to when Caden called her, it was 20 minutes. So sometime before 9:45 to when Caden called her, which was before he called 911, it was 20 minutes that he had the opportunity to be in that house. And this supposed rage, the night of the fire, she said he was cool with Schuster, and Laux, she said he was cool. She said it surprised her that he did it. Neither time a mention of the gun threats or anger. Oh, and known him as a friend for 6 years, never seen him with a gun. Thought he might carry one, but she said she'd never seen him with one. But let's face it, folks, they had sexual relations and she'd seen him naked, so if he was carrying a gun, there was probably a chance for her to see it. If he was staying over, there was probably a chance for see it, but she never saw it. All of a sudden, he's got this gun. Then the boys. Can we say a mind on drugs is a terrible thing? Used to be commercials about that. 19 and 14. How is weed, carts, blunts on the 14-year-old, you know, whether you're smoking in mom's living room, whether you're smoking blunts back in mom's bedroom, how does that affect your perception, your paranoia, your memory? And it was like 2 separate evenings when you had Caden up here and when you had Trey up there. Caden was in mom's room with Trey and Gabby. When Chris showed up, Trey said that they were in his room with the door shut. Caden said that he was in Trey's room when Chris came in and said, if your mom isn't home in the next 15 minutes, I'm going to burn this bitch down. Once he said house to Laux, but then he changed it to bitch. And when talking to Laux, he also changed it from mom to Chelsea. I asked him about that. In fact, Mr. Pitzer told him he could use colorful language. And that's when he changed it to bitch. Trey, if your mom is not here in 10 minutes, I'm going to burn this motherfucker down. Gabby, what did she hear? You know, they seem to imply that Gabby was indisposed because she'd had a C-section 24 days ago. Laux, lead detective in this case, didn't try to talk to her. One of the 3 eyewitnesses, a potential eyewitness.
Yeah, because she didn't have any parental supervision for the interview. There's no parents in her life.
Wasn't aware Gabby's number was in Schuster's video, although he said he reviewed the video before he went further because that was on the scene. Wasn't aware Gabby's parents' name were in the Schuster's video and his body cam. Nope. He'd escaped to the wilds of Muncie, Indiana. You know, how are we going to get her back from there? God forbid, with the debilitations of a C-section, she can't be found except, oops, Chelsea's on the stand and says, I gave him her address and phone number a few days before this. Lead detective had that information before this trial. And we're just finding out here that Chelsea gave him that information just recently on how to get in touch with her, because grandmas know. And she has a new grandma. And so Chelsea told him where Gabby was. Why is she not here? what would she have said? Why would they decide we better not bring her here and put her on to complete this full story? Because the other two stories you heard, Trey and Caden, didn't match up. They didn't match up. She was the only one, according to Caden, that wasn't smoking weed. And according to Caden, she was in the room when Chris was supposed to, or supposed, when he threatened. She could have added a lot of light if they'd have brought her here, and they had it within their ability.
She left her mom's house, V. She doesn't live with her mom.
She's not here.
Well,
So we're left
might
with
now,
the,
but she
I'll call
wasn't
them
then.
weed-addled teens, 114. Remember Caden? Gunn was clear as day. He was interviewed twice. And in his interview prior to his testimony here today, he not once mentioned a gun. Said it wasn't important. Never brought it up. House is burned down. Not going to bring up the gun. I will point out too, folks, that with regards to count 2, intimidation. If you want to believe Trey, he was in the hallway of the trailer, manufactured home, when Christopher Williams supposedly threatened him. Threatened him with supposedly to burn this MF down, and supposedly my cousin's out in the woods, or you should go hide later, and he's going to shoot you. We're going to shoot you. Where was Caden? Oh, he wasn't there. He was behind the door. He heard it because he was behind the door. So the intimidation says that he made the threat to Caden LeGrand. But
Smurf. That's why he didn't mention the gun in the first interview, because it was plastic.
Trey said he made the threat to him, and Caden was on the other side of the door. He didn't know where Gabby was, although Caden will tell you that all 3 of them were sitting in the bedroom. I don't think Caden even remembers being there from the way he testified and the way Trey testified. They're 2 really different stories. I didn't get together very well on that. But if it did communicate a threat to unlawfully injure Caden, but he was talking to Trey, I'm going to get to the elements to Caden from the information that you're going to have in your instruction. If you have 2 alternative reasonable theories, you must give the defendant the benefit of the doubt. And he's not charged in count 2 with threatening Trey. According to Caden, that right after the supposed threat, the threat was made, what happened next? He took tail and ran. I asked him, he left before you did? Yes. We were in the house and he took off. I went to the door and watched him leave. I saw him drive off. I asked him, did you go outside at any time? Nope. I was in the house and the whole time he was there, and then he took off, probably took tail and ran. He left before us. Then I started smelling a chemical smell. I asked again. They did not leave before Chris. If you remember, when I was talking to Caden, I was trying to align his story with Trey's. I kept saying, isn't this? And he kept denying it and going back to his story, which was different than Trey's. I was giving him the opportunity to align their stories. which they should have done in the last 18 months, but they didn't do a very good job of it. Because I told two disparate stories. And as I tried to align those stories, Caden wasn't having it. His version was different. Their stories didn't align, not even the threat. The Trey heard in the hall, and Caden heard with all three of them in Trey's room. If your mom's not here, if Chelsea's not here, burn this house down, burn this bitch down, burn this MF down, 10 minutes, 15 minutes. Ms. Clay's made a big deal about, oh, how traumatic this was. 14-year-old, 19-year-old, how traumatic this was. If this was that darn traumatic, you don't forget that stuff. And I'll tell you something else. You don't forget the truth. You do not forget the truth. It's your fabrications that you miss the details on sometime later. And it's only 18 months. It's not like it happened in 1920 or 2020 during COVID. This happened just 18 months ago. And then I asked Caden, the night of the fire, when he was talking to Schuster, didn't he say, if your mom is not here to help me move my stuff in 10 minutes, I'm going to burn this house down? And he said, yes, that's what he told Schuster the night of. Well, now he's supposed to move stuff. There must have been a lot of stuff if he was going to have to wait 10 minutes to have help doing it.
I forget
How much
truth
stuff
and
did he
lies
have?
equally. I just forget.
Enough took him the whole 20 minutes that he was there.
I forget
Speakers,
what this
grow
trial's
kits,
about.
or whatever the kits were, stuff scattered
Feedback
all through the
plan.
house. Trey said he had stuff scattered all over the living room. Clothes. At one point, Trey told Laux, oh, he had the gun. I saw him when he put it in his pocket. He was carrying it in his hand as he was walking around the house picking up stuff. That makes sense? You're picking up stuff, but you got your gun flashed in your hand. Big speakers, 4 feet by 15 inch, 4 feet by 18 inch, or wherever, these 5 foot by 18 inch kits of some kind, and you're carrying around a gun as well. He was loading the car, took a break, made the threat, and then went back to loading his car. Now, Trey's story, whereas Caden said they never left the house, they were there the whole time, is that they took him a while, 4 or 5 minutes, to put on warmer clothes. He said then they went out to some basketball park or some parking lot, whichever, on the corner of the west and north Hawthorns, whichever. And they were there for a while. Then they were in a circle talking, and that's when they saw
Kentuckian.
Chris
Ben.
drive off, Mr. Williams drive off, and that's when they went to the house after he left. And they were sure he was gone, so they went to the house. They were there, looked around the house, looked to see what had happened. While he was in the house alone and they were out. 4 or 5 minutes later, they look around the house again, and that is when the door was locked. Then he had to go get a butter knife, and then he had to come back and unlock the door. Caden, no mention of the locked door. Now, he didn't add that fact in there. So they had left, and Caden had him in and out while they had never left. Took tail and ran. As I pointed out, Caden said they left the house, walked down to the park. Then they headed back, looked around. It was then they started looking again, opened the door with a butter knife, or the kind of door you would open with a butter knife. They didn't obviously just go over and use their thumbnail. Then the bathroom door. And then Trey said they ran outside of the house. Caden said they just started gathering things, when Chris hadn't left. He ran outside of the house and then he ran back into the house to get his stuff, had to get the Xbox. And then out to the bushes where Chris was hiding to shoot him. Again, story not well thought out between the two of them. And all over a non-relationship with no sign of a lover's scorn. They were just friends with benefits. And all of a sudden this pops up after 6 years. You're being asked in this matter of the highest importance, and I'm sorry they're doing this to you. They're giving you 2 kids. That's your evidence. Chelsea wasn't there. They're not giving you 3 kids because they didn't bring Gabby. She's all the way in Muncie. Can't be here because she had a C-section 20 some odd days ago. They're giving you 2 kids to put this man's future in your hands based on the inconsistencies and the credibility issues with those 2 kids, to decide his fate. And what boils down to Caden and Trey. Mr. Pitzer asked you in voir dire, do not discount them as witnesses because of their lack of sophistication or the way they speak as youths. So folks, don't give them credibility that you think they deserve if they'd have been older or if they'd have been more sophisticated. If they wouldn't have been up here chuckling, stretching and yawning and covering their eyes and like they didn't want to be here, not because they were scared, because this is pain. And they don't know if they can remember the same story twice. You don't forget the truth. You don't say, I don't remember. It was a minute ago. Because that was, as Katie Clays pointed out, Miss Clays, this was traumatic. You don't forget the traumatic, and you don't forget it if it's true. Do not fill in the gaps of their memories. They leave the gaps they leave in their memories. Their excuses for it being a minute. Their discrepancies. If they tell 2 different stories, you can't speculate as to what they might have said if they'd have been here on the 9th of September of 2024 or under different circumstances at another time. They might have done better. You don't get to say they might have done better. It's not enough to prove probably. You have to rely on what they said here. And those are inconsistent. And you're putting a man's future in the hands of those inconsistencies. You can't say there might have probably been a better way for them to tell their stories. Have the stories that they told from here, from that box, that witness box. Most likely, though, their stories aren't any better if you get them on a different day. They're best friends. They're together constantly. They couldn't get their stories aligned better than what they did. I'm sure you can probably guess they've talked about this. Doesn't happen, something that traumatic, and you don't bring it up to each other. Can't speculate that had they not been high that night, they'd have done better remembering today. They would have remembered better. Can't speculate that and fill in a gap. The instruction calls, as you will hear, Chris getting the benefit of the doubt when it comes to beyond a reasonable doubt. They don't get the benefit of the doubt. They're stuck with what they say and how they testify. You wouldn't want a 14-year-old smoking pot and driving your car and be in his hands. And you wouldn't want your son to be in the hands of a 14-year-old kid smoking pot and trying to remember what the heck happened and testifying inconsistently. Don't overlook the inconsistencies, the lack of credibility, the discrepancies. If you're going to put Chris's life in their hands, they have to be really, really strong. And they were not. They were not strong witnesses. They were not serious witnesses. They gave you imperfect witnesses and asking you to convict Chris, Mr. Williams, with that. And that's why I said earlier, I'm sorry they did this to you. They put you in this position. If you convict, you will second guess yourself, and it will linger. There will be doubts. And as it lingers, you'll see it as reasonable doubt eventually. Problem is, you don't have time to linger today. You have to decide on all of those doubts. Do you put someone's life in the hands of those two kids today? And remind you, Detective Lau
We have eye color too. Weight, height, eye color.
said he spoke to Mr. Williams for about 15 minutes. Chris tried to explain how he didn't do it. That's what Laux testified to. He cooperated. Laux said he may not have found it helpful to use against him, but the fact that he did offer something, I hope it helps you. This may be very unsatisfying, not knowing what happened, but that's knowing what happened really isn't your job. What your job is with what they gave you. Did they prove this beyond a reasonable doubt? It's not enough to convict, as you will hear in the instruction, that somebody probably did something. Can't fill parts of the puzzle as to what probably goes there, speculate as to what might go in there. But you can't say that beyond a reasonable doubt, the two witnesses they gave you are credible enough to rely on in this matter of the highest importance. Sometimes your job is to say, we don't know. And if you don't know, that's not beyond a reasonable doubt. This is not a game to Mr. Williams. This is not a game for you. It's not a game for the prosecutors. It's not a game for me. But folks, this was a game. What you saw, the display you saw yesterday was a game. Hayden and Trey, as I pointed out, laughing, yawning, stretching, annoyed. And I'll remind you, at some point, Caden was upset he lost his music, his radio, his amplifier, his speakers. Chris took those. He took their amplifier, he took their speakers, and he took his Xbox, which they were playing back sometimes in Mom's room. Now, Mr. Pitzer's going to get up here and say, Mr. Bajeric is attacking those kids. That's all he's got is to attack those kids, because that's all they have is the kids. That's all they have are those two kids. There's a fire someplace. Who started it? Oh, we'll go to the two kids. They better be pretty good. They better give you strong evidence that you can rely on in this matter of highest importance. They better give you the kind of evidence that you can go home and look at your kid and say, you little so-and-so, I just heard the strongest evidence against you, and I know you did this.
You know, this is very difficult to believe. I can't even believe that I'm saying it. Sometimes kids actually tell the truth. I know. It's really not often. Sometimes they do, though.
Or, I have a doubt. Is that doubt reasonable? You can't throw it away. That's what you have. lack of credibility, lack of memory. Apparently, it looked like a lack of respect for the process. It's not an excuse that he's 14 or 15. You're old enough to have kids. You're old enough to be responsible for yourself. You're old enough to take charge for yourself. You're old enough to take responsibility for a serious moment. The testimony, is infirm as it is what you have. What I'm going to ask you to do Oh, and I will point out, Ms. Clay said that according to Detective Laux, it was like a 15-20 minute drive from Hawthorne to County Road 5, Elkhart Road, State Line Road. If you recall his actual testimony, it was a 15-minute drive from Oslo on County Road 6 to Hawthorne. If you think you can also drive from Hawthorne past all of that and still get to Elkhart Road and State Line Road in the same 15 minutes.
I could have done it
We
in
saw
half
the
the
map.
time.
I mean, I'm going to ask you to go back, take the verdict form. If you believe Trey's testimony, Caden didn't get a threat. If you believe those kids with regards to this fire, and you're going to put another man's life in their hands, that's up to you.
What if we just don't
They've not
like
proven
you?
this case beyond a reasonable doubt.
What do we do?
Look at count 1, the arson, and we're going to ask that you find that where it says not guilty, that you check that box, not proven. The same thing. They haven't proven this case beyond a reasonable doubt. With regards to intimidation, we're down here where it says not guilty, again, not proven against Caden. Take your time, deliberate. This is a matter of the highest importance. And this is probably one of the most important things you can do in your life. Because how often do you get a chance to hold another man's life in your hands? His future.
Every day.
Thank you very much.
Thank you, Mr. Jerry. Get your rebuttal closing for the state when you're ready, please.
Thank you. I'm sorry that we're doing this to you. I'm sorry that you're being asked to believe these kids. I'm sorry that a man's future is in your hands. Okay, the argument that his life in your hands is actually objectionable, but I thought I wouldn't slow the process down. This was a game. This was a game to Trey and Caden. This was a game. The reason we're here 100% is because that man right there got pissed off, couldn't control his emotions, threatened a bunch of kids, and lit a house on fire. That's why we're here. His future was in his own hands when he decided to commit these very, very serious criminal acts. We make no apologies for bringing this case to trial. golly, if this isn't good enough for a jury of 12 intelligent people, perhaps we should just not charge any crime going forward. Or if we've got victims that happen to be kids, well, if we got kids that are victims, you know, they're just not to be believed. It's just a game to them. I mean, as I sit here and listen to this sometimes, no disrespect to Mr. Majerick. He's got a job to do, but it's offensive. It's offensive. During the course of closing argument, I think I heard from defense counsel the word Chris or Chris Williams twice. Okay, what does the defense attorney want to do? Point the direction, smoke and mirrors. Okay, let's not look at what the evidence was. Let's talk about the fact that the state has to prove the elements beyond a reasonable doubt. We do not have to prove exactly what time this happened. We do not have to prove whether or not this was said in the living room or the bedroom. We do not have to prove how long somebody was gone, whether there was clothing moved. We do not have to prove all these different things. There's a reason for that. Because at the end of the day, the fact is that a fire was set in that house. And it was either set by the defendant, or I suppose it was set by these kids that lived there with all their stuff. I mean, what makes the most sense? It is necessary that every essential element of the charge, a crime charged against the accused, should be proven by the evidence beyond a reasonable doubt. Every essential element. Okay, that's why we go through this on Monday with you all. That's why you're going to get the elements. That's why Ms. Clays put this up. That's why we talk about that. You must consider all the evidence as a whole. Okay, this is a story of an entire event that's being told by multiple different people who have their own memories of exactly what happened. They have their own memories of how it affected them. This is what's called real life.
So they did say something that's false, and they've said it over and over in this trial. So vapes absolutely 1000% can start a fire. There's a little button on a vape. If you press it, it heats up a piece of cotton. It heats up coils inside of a piece of cotton with oil. So if it's in your purse, in your jacket, and it's in a position where the button is pressed in and it just keeps heating and keeps heating, yeah, it burns. It burns very, very, very hot. So what if, guys, what if there was just a vape in the laundry basket, and as this guy was moving, he put stuff on top of that in a way that that button was pushed in? What if this was just totally an accident? Totally. Absolutely just accidental.
You must consider all the evidence as a whole and must not single out any particular fact or circumstance. Okay, because Trey and Caden, and let's put Chelsea into the mix. He wants to talk about Trey and Caden. I assure you that if they came in and walked up to the stand and they told a story that matched up 100%, what do you think we'd get from defense counsel? Well, I can tell you, these two best friends came, made this all up. They've been sitting around talking about this forever. They wrote their own script. They're coming in. They're going to say exactly the same thing to you all. The state would have concerns if that was what was happening. Then it would be rehearsed, then it would be planned. These are not some masterminds of conspiracy theory that as soon as this fire got lit, go out and hang out in the park And they're like, no, we're gonna need to go through this and figure out exactly how to say this and exactly what the threats were and what the gun, the fire, so forth and so on.
Yo, vapes are all the time in your clothes basket. All the time. you forget where they are. Then you put them in your pocket, then you get changed, then you're about to leave. Oh, where did I put my vape? You gotta search through your clothes.
These were kids who had no expectation that there was going to be some startling event, some life-changing event for them take place that evening. Okay, these are not people who are like going, oh my gosh, I need to remember, did I go get chips and salsa? Who went first? Did somebody use the bathroom? Who won the game? These are people who are just going through their day-to-day life with no expectation that they are going to be going through this event and being expected to very specifically describe it and explain it immediately after it happens, the next day after it happens, the next month after it happens. And then here we are. And this is the system. It takes a while to get here. September 8th up to February 16th. And now all of a sudden they're going to be asked to do this again. And they're supposed to be 100% down the pipe, exactly the same things that they said. That's not real life. You understand this. Life experience, knowledge, common sense. There's no indication that somehow they wrote a detailed diary after this happened. There's no indication that somehow they made their own audio recordings. There's no indication from anybody that they were even allowed or encouraged or asked to sit down and listen to the statements they gave, right? Because the state doesn't do that. Because if we did that, then what you would get is, well, of course they're saying the exact same thing today because they sat down with Detective Laux and Fire Marshal O'Brien, and they were reminded of their testimony. No, we didn't do that. Yes, Mr. Majeric is correct about some things. The blame game is just remarkable to me. It's remarkable to me that here you've got these kids, Travion and Caden and Gabby, and somehow they are the ones that are being attacked. It's their house that burned down. It's their stuff that burned down. But yet we come into a court of law. It's like Chris doesn't even exist. This defendant even exists. We are just going to attack and attack and attack these kids. It's just painful to watch. You know, I wrote down on my sheet.
Some of this was painful to watch. You do have that right. That was correct.
It must really suck to be the witness to a crime. It must really suck to be the victim of a crime. Not only do you have to go through this traumatic event, but then you have to relive it with law enforcement, with the fire department. Then a year later, you're expected to come into court, this formal setting. You have to be in the same room with the guy that threatened to shoot your mom, threatened to shoot you, and burned all your stuff. You got to come in. Be all formal, sit down. Then you're going to be scrutinized. How did you say this? How did you say that? Were you shifty? Were you goofy? Did you put your hands up? You're going to be attacked and attacked and attacked and attacked. You wonder why we didn't call Gabby? You want to blame somebody for not calling Gabby on behalf of the state? Feel free to blame me. We didn't need Gabby to prove our case. And oh, by the way, even though the defense does not have to present a case, they can subpoena people too. Right? They don't don't have to present a case. It's America. They can subpoena her too. We're supposed to bring her in so she can get attacked. She can get blamed. When you start talking about memorizing or remembering events, I was talking to my mom either last night or this morning. My mom's birthday was Saturday. We went down to Indianapolis. My sister came in. And I started thinking about this. I'm like, if somebody asked me to do a blow by blow, an hour by hour, a minute by minute, a second by second, who said what? Who went where? Were we watching the curling or was it the skating? Who got what for lunch? Who got up and went to the car to get the charger? What time was that? I mean, this again is real life. People do not have the ability to just recall and remember events like that. Now let's go back to Thanksgiving. What happened in Thanksgiving? You know, I'm not even sure I know where we had Thanksgiving last year. So people's memories are what they are. You have to look at the totality of the circumstances. Look how actually consistent these stories are. And it's not just Trey and Caden, it is also Chelsea and what she had to say and what the threats were that came from this defendant. Let's talk just briefly about the credibility instruction. Obviously, it is important that you analyze and make a determination about the believability of all the witnesses. While it is apologize.
Anthony tried to set the house on fire a couple times, but the one time in particular, he wanted ramen. We have the cup of noodles. So it's the ramen noodles in the styrofoam cups. You just peel back the lid, you fill it with water, you put it in the microwave, 3 minutes, and it's done. I was at work. I only worked like 7 blocks away from the house. Okay? I was at work. They got off school. They came home. Vicky was 14, Tiffany was 12, Anthony was about 10. Give or take. And Anthony wanted ramen. He asked his sisters to make him ramen. They both said, no, I'm not making you ramen. So he took one of those styrofoam cups and he put it in the microwave with no water in it. So my eldest noticed that it was on fire. Everything was fine. She got it out of there and she put it outside on the wood porch. That's when the fire company came because she set the porch on fire. But at least she tried. She did her best.
Credibility of the witnesses. So you're going to get a bunch of instructions. This is going to be one of them. You are the exclusive judges of the evidence, which may be either witness testimony or exhibits. In considering the evidence, it's your duty to decide the value you give to the exhibits you receive and the testimony you hear. In determining the value to give to a witness's testimony, some factors you may consider are the witness's ability and opportunity to observe. Okay, these kids were right there when this took place. Chelsea was right there to be able to listen to what was being said on the phone. The behavior of the witnesses while testifying. I would suggest to you on behalf of the state that when Chelsea, let's not forget Chelsea. I mean, defense counsel wants to focus entirely on Travion and Caden, but Chelsea took the stand. From her ability to observe the things she observed, from her behavior while testifying, is there anything that would make you just go, I don't think so? Anything about the way that Travion and
Pitzer, a whole bunch of people in chat said that. I didn't understand, but they all did. They're like, she's lying. She's lying.
Caden testified. I would suggest at the end of the day, they cleaned up pretty well and came in and did their best to explain to you what happened. And now they're being attacked. The reasonableness of the testimony considering the other evidence is all the evidence when viewed together, which includes the fire, which includes the flock cameras, which includes the vehicle. This isn't all just coming down to Travion and Caden. There's much more evidence that we put on than that. Is the testimony of these individuals reasonable in light of the other testimony and evidence in the case? You are encouraged to use, and this is why we talk about this, your knowledge, your common sense, your life experiences. And I would suggest to you all of that and the use of inferences, logical analysis, rational thought, moving from A to B, that all points in the direction of the fact that this defendant is guilty. I want to talk just briefly about the nature of this offense.
If you smell gas, don't make breakfast. Don't turn on the oven or the stove.
Arson is a particularly egregious and horrific offense. We don't do a lot of arson cases, thank goodness. But when you light somebody's possessions on fire, and you light a house on fire, a residence on fire, a place on fire that has recently had human beings in it, you are going to a special length to try to attack somebody. The first time I saw these pictures on behalf of the state, it made me sick to my stomach. We don't do a lot of these cases.
You liar. He's a
Fire
liar.
is a particularly harsh way to attack belongings. It's a particularly harsh, a particularly personal, a particularly destructive way to go after somebody. And that's what he did. And now he wants to come into court, and through his attorney, he wants to blame these kids for doing this. I would suggest to you that while you might not condone all the different things that these kids were doing, you might not condone the activities of Chelsea Reeves. She is a decent person. She's a place where people can come, the kids can come when they've got tougher circumstances. These are humble people with a humble place and humble belongings. And this destruction, complete and utter destruction, is what this defendant did. What's it like to have that be your house? That's your bed.
It'd be an upgrade. Hot water heater made it though. That's a big expense. So that was good.
Somebody lit that fire. I suppose it was either this defendant or was those kids. It wasn't the kids. You know that. You know that we have proven this case beyond any reasonable doubt. I indicated the case would be fairly straightforward, and at the end of the day, I would suggest it was. It's kind of interesting as we're writing our quotes and doing our job that under cross-examination by Mr. Majerick, in some ways, kind of the moment that I will remember from this trial, and I remember all the trials I've ever done, I will remember Travion on the stand being asked these questions and drilled down upon about who is that would have lit the fire. And did you see the fire lit? And X and Y and Z and let's attack and attack and attack. And Travion, the 14-year-old, under cross-examination was asked about, well, then you don't, how could we possibly know who did it? Remember what he said? Common sense? That's the 14-year-old. The state has proven this case beyond any reasonable doubt. We're asking that you go back, deliberate as appropriate, return a verdict of guilty on the arson, return a verdict of guilty on the intimidation. We have anger, we have threats, we have arson. We ask that you go back and do your job. We appreciate it. Thank you.
Anger, threats, arson. No, you can't, Sherry, but you can Facebook chat each other. You can use Discord.
Please. Thank you. Ladies and gentlemen, the jury, that concludes closing arguments from counsel.
You can do video calls on your smartphone. $20 is $20, Bobby. I haven't the slightest idea what we're waiting on right now. I know she's doing something. You can see something happening on the TV. Oh, all right. I think I know. I think she's putting jury instructions up on the TV, right? I really thought I cut them out. So, yo, brooms. You don't have to get a really expensive broom for it to work. Just saying. Capricorns are stubborn, Sherry. Alright, I'm going to fast forward. I know I'm going to mess up. Alright, we're at 1 hour and 30 minutes. Let's go to 1 hour 32. Oh, still not there yet. Miss Clays is helping her. 35.
Follows. The affiant of the probable cause affidavit filed herewith swears that on or about September 8, 2024, at the County of Elkhart and State of Indiana, when Christopher Williams did communicate a threat to unlawfully injure Caden LeGrand with the intent that Caden LeGrand be placed in fear that the threat will be carried out, and the threat was to commit a forcible felony, to wit, defendant would shoot anyone who left the dwelling, all of which is contrary to the form of Indiana Code Section 3545-2, 1A4 and B1A, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. The crime of arson is defined by law as follows: a person who, by means of fire, explosive, or destructive device, knowingly damages a dwelling of another person without her consent, commits arson, a level 4 felony. Before you may convict the defendant, the state must have proved each of the following beyond a reasonable doubt: 1, the defendant; 2, knowingly; 3, damaged; 4, a dwelling of another person, Chelsea Reeves; 5, by means of fire, explosive, or destructive device; 6, without Chelsea Reeves' consent. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty of arson, a level 4 felony, as charged in count 1 of the charging information. The crime of intimidation is defined by law as follows: a person who communicates a threat to another person with the intent that the other person be placed in fear that the threat will be carried out. If the threat is to unlawfully injure the person threatened or another person, commits intimidation, a Class A misdemeanor. The offense is a level 6 felony if the threat is to commit a forcible felony. Before you may convict the defendant, the state must have proved each of the following beyond a reasonable doubt: 1, the defendant; 2, communicated a threat to Caden LeGrand; 3, with the intent that Caden LeGrand be placed in fear that the threat to unlawfully injure Caden LeGrand would be carried out; 4, and the threat was to commit a forcible felony. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty of intimidation, a level 6 felony, as charged in count 2 of the charging information. Under the Constitution of Indiana, you have the right to determine both the law and the facts. The court's instructions are your best source in determining the law. Definitions. Knowingly is defined as a person engages in conduct knowingly if, when he engages in the conduct, he is aware of a high probability that he is doing so. The term dwelling is defined by law as meaning a building, structure, or other enclosed space, permanent or temporary, movable or fixed, that is a person's home or place of lodging. Communicates includes posting a message electronically, including on a social networking website. The term threat is defined by law as meaning an expression by words or action of an intention to, 1, unlawfully injure the person threatened or another person. Value of the testimony be permitted to listen.
Okay. Now it's time for the verdict. I don't want to fast forward right here because I'm scared I'll go too far and then we'll miss it. Alright, I'll go one more minute. Oh, I thought it stopped playing.
Counsel, Mr. Williams, I've been advised by my bailiff that the jury has reached a verdict. Mr. Pitzer, is the state ready to receive the verdict?
Yes.
Mr. Majerick, are you and Mr. Williams ready to receive the verdict?
Yes, Your Honor.
Let me remind everybody, it's only one person. Let me just remind you that no cheering, no yelling, no anything. You have to remain sober and somber and accept this. When you get out on the street, you can yell and scream all you want as long as you don't commit a crime. But in here,
it's Pitzer or Pisser.
it's very, very civil always. No uncivil nature. And I have no doubt I didn't need to tell you that because you've been quite civil through the whole trial. Would you bring the jury in, please? felony. And again, it is dated and I will address my remarks to all of the jurors, but the foreperson will answer on behalf of the jury. Ladies and gentlemen of the jury, have you reached a verdict in this case?
Yes.
The foreperson of the jury will please deliver the verdict to the bailiff, and the bailiff will present the same to the court at this time.
V. Smurf on Twitch says don't feel too bad because his mom was 5 foot nothing. I'm 5 foot 2 3/4. My husband was 5 foot nothing.
20-01-25-01-F43, State of Indiana versus Christopher Williams. The verdict reads as follows. Count 1, arson, a level 4 felony. We, the jury, find the defendant, Christopher Williams, guilty of arson, a level 4 felony, and it is dated and signed by the foreperson. Count 2, intimidation, a level 6 felony. We, the jury, find the defendant, Christopher Williams, guilty of intimidation, a level 6 felony, and again, it is dated and signed by the foreperson. Foreperson of the jury.
Both guilty. Guilty of intimidation, guilty of arson. However, we all know because of that whole not being able to present evidence about the other fire and everything, this is going to be appealed.
Jury, is this the unanimous verdict of the jury?
Yes.
Thank you. Any motions?
Your Honor, we have motion to uphold the jury.
Yes. Juror number 4, is this your verdict?
Yes, it is.
Juror number 6, is this your verdict?
Yes, it is.
Juror number 11, is this your verdict?
Yes, it is.
Juror number 12, is this your verdict?
Yes, it is.
Juror number 13, you are released and discharged from verdict of the jury and enters judgment of conviction on the verdict and enters judgment of conviction against the defendant, Christopher Williams, for count 1, arson, a level 4 felony, and count 2, intimidation, a level 6 felony. Ladies and gentlemen of the jury, I thank you for your service. I'm now going to release you and discharge you. It is my custom and practice to come back and talk to the jury after a case is over. I also ask counsel to come back. I want to be clear, if you've had all you want to have in circuit court, you've been here with me the better part of 3 days, you know nothing you can do will offend me in any way whatsoever. So if you are ready to go home to your jobs, your family, your friends, your life, and you're done with circuit court, you go with my heartfelt thanks. We could not have justice in Elkhart County if we didn't have fine citizens like you that do show up. If you want to stick around for a little while and have me answer some questions, perhaps you've got questions for counsel, I will we'll all make ourselves available to you. You are released and discharged from your summons to serve as jurors, and you're in charge of my bailiff for the very last time. Thank you.
All right.
That's you. You know what YouTube is saying to you, JK. JK, you know what YouTube is saying to you. It's frustrating, though. I know it's frustrating. I do.
You may be seated. Mr. Williams, it's my custom and practice if a jury verdict is rendered and the offender is found guilty that I revoke bond. I hereby revoke your bond. I'm going to order probation to prepare and file with the court a written pre-sentence investigation report. Sentencing will be March 19, 2026, 8:30 o'clock a.m. And I hereby remand you to the sheriff. We'll have you brought over for sentencing.
Guilty on both counts, Bobby.
What's your charge, please?
Any record you need to make, Mr. Pitzer?
No, thank you.
Sorry, Deb. Thank you, though.
Mr. Majerick, any record you need to make?
Your Honor.
That concludes the trial.
That's it. He stopped it before we could see what was going on. And like his current girlfriend or mother or sister or somebody was crying that he was going to jail. But he did go to jail right then and there. And then I don't know if he gets out on probation before March 19th. But we'll find out, because he's going to have a bond hearing before that, and I get every single Indiana case now, have it set up that streams. If they stream in Indiana, I get it. All of it. I don't miss any of it. And I get Judge Fleischer. I have it set up that I get all of him automatically. I won't miss any of it. So we don't know how much time he got because March 19th is the sentencing. If I get that, I'm only going to get, just so we get what it is. We're not going to go through the whole sentencing. Yeah, no bond. His bond was revoked. I do have some, tomorrow I'm going to show an interesting clip about Judge Cristofino a little bit. But it's not Judge Cristofino. And you'll see what I mean. But I'm going to show that tomorrow. If you're here for court is over. Done. We did it. We did that whole trial like it was nothing. Now we're done. I got a lot of stuff for you guys. It's just going to be hard picking and choosing. Yeah, we don't want victim impact. No. We just want the verdict. I mean the sentence. And that's what I'm going to give you when we get there. Too bad we don't get Broadway. I'm going to say that for a while. Hi, Maria. Because that one hurt my feelings that went to Judge Toady. Or Toady. So, yeah, tomorrow morning, I should be here. I'm going out. Going out tonight, guys. I got tickets. Big group of us is going out. And I'm so excited. It just took forever to get here. You know when you're waiting for a big event? And you're waiting, and you're waiting, and you're waiting, and you're waiting. Today is the day. It's finally happening. And it's 12 hours from now. I know, it's early, but we're going to be out late. It's a long night. But I should still be here tomorrow, I promise. I hope that you all guys are all too. I think someone just asked me a question. Shannon. Yeah, I don't know. I'm going out on a limb, Shannon. I'm going to say since he streamed yesterday, Judge Fleischer, and Judge Fleischer streamed the day before, I'm going to go out on a limb and say he is going to stream today. But I don't know that. And sometimes he takes a day off of work, like naturally, for some reason. So it is possible he doesn't stream today. For whatever reason. That doesn't mean he's not streaming anymore, or he is back or isn't back. I'm guessing he's back. That's just what I'm guessing, because he did all that work to set his cameras up in a way that you don't see anybody. Why would he put in all that work if he wasn't going to stream again? Thanks, V. So, no, it's not a concert. It is a show, but it's not a concert. I'm not going to... Listen, there's the chance of me getting arrested is not zero, but it's might not happen. I'm going out to have fun. We are going to have fun, and we need it because my son is going too. Yeah, he took off work for this, so I did punch my son 4 times yesterday, and realized that the dynamics have changed because he didn't even realize I was punching him in the arm. He didn't even realize it. He couldn't even feel it. I'm driving down the road, and me and my son lately I've been like, are you dating anybody? No. Does anybody think that you are dating them? No, I'm not dating anybody. So we're driving down the road, I think it was yesterday. I don't know. Mushed together. I don't know. I think it was yesterday, the day before. Driving down the road. I'm driving him to work, or I'm driving him home from work, and he's like, "Yeah, well, I broke up with Lexi." Like, what do you mean you broke up with Lexi? You know, you said you weren't dating anybody. Yeah, well, we decided to try it. So I started dating Lexi, and I broke up with Lexi because she cheated on me. All right, that sucks. And he's like, and then, you know, we broke up, so I decided to go to Jewel's house. Jewel is another girl. And I'm like, who's Jewel? He goes, well, she's really, really, really crazy. She is absolutely psycho, Mom. I'm like, Anthony, what? So I'm driving. Just found out that he was dating someone, didn't tell me. We tell each other everything, you know what I mean? And then he hooked up with this other girl, didn't tell me, and she's psycho, and he's like, yeah, she's 36. And right away I was like, what? Anthony's 22. She's 36 years old. So I overreact right away. And I, verbally start saying, what do you mean she's 36 years old? What are you doing? She's psycho and she's 36 years old. What are you doing? Blah, blah, blah. And then he went too far for me. He's like, well, she just got out of jail. Oh, that was it. My hand went, boom, stop. Stop it. He didn't even realize that I'm trying to drive a car while physically assaulting him. And he's like, he's like, so now I realize, that, he's huge. I don't know how big he is. I don't know how tall he is. To me, he towers over me. And he's very big. Anthony is. He has a lot of muscles and he's real tall. And he looks 30. He looks like he's 30. He looked like he was 28 when he was a freshman in high school. He has big beard and mustache. But yeah, he was. So she wanted him. She just got out of jail. She wanted him. He goes over to her house and she's like, you have to go into the bathroom and shave your mustache. I don't like it. He's like, no, I'm not shaving my mustache. She's like, yeah, I don't like it. You just got to get rid of it. Look, go into the bathroom, get rid of it. He's like, no, I'm not getting rid of it. So then she's like, I think you should move in here and I will pay for your college. He said, you don't have a job. You just got out of jail. You don't have a job. She goes, yeah, but I think you should move in here. And, so it's been unbearable here lately. It's been very, very, very stressful for everybody, right? So this 36-year-old is like, you should come and move in here. And my heart, dropped. Because a 22-year-old who can, get away from that, has a free place to go, I would have said yes. Hell yeah, I'll move in right away, He's like, no, I'm not. You're crazy. I'm not moving in. You just got out of jail. You don't have a job. You don't have a job. And he didn't move out. That was pretty cool. That was like a grown-up thing for him to do. I can't believe he did it. But when you say you're going south, Smurf, where is south? I wonder. Where is south? Oh, Linus. I'm going to try to get some pictures today, Linus, because I'm going to pass by Dutch Wonderland, and I'm going to pass by Dutch Heaven, or Haven. So, do you have a lot of... this is going to be a weird question for you, Linus, alright? So, do you have a lot of hex signs there? Because in our Pennsylvania Dutch section of Lancaster, everybody sells these hex signs. I'm going to get some pictures today, so you'll know what I mean. But, do you have a lot of hex signs where you live? I have to know. I don't know if it's just a Pennsylvania Dutch thing or... Oh, so north? Okay, well, he's pretty far south. That's crazy. You're going to Texas and you're going to be 6 hours away from Judge Fleischer, and both of those are true. Yeah, we have a lot of hex signs. Linus, I'm going to show you some of them. I'm going to show you a whole bunch of Dutch stuff. Do you have shoe fly pie? Shoe fly pie? Where you are, Linus? Maybe it's called something else. Molasses. That's the biggest part of shoe fly pie. That sounds fun. Smurf, I hope you have a good time in Texas. Don't get arrested. Yeah, I'm going to get you some pictures. I know, Bren. I know. I got a lot of Australians. I really, really wish, because of the time zone that I stream in, I really, really wish I would get a bigger crowd from Australia, from the UK, Finland, Germany. I wish I would get more. You know what I think I have to do? You know what I think I'm going to do, guys? You know what I think I'm going to do? My descriptions and my titles, I think, for the rest of March, for my live streams, are going to be hard. They're going to be all UK, Australian based. I'm going to say barrister instead of lawyer. I'm going to say this bloke, got the judge mad. Wait, what did we call judges in the UK? Is it judge? I'm gonna have ChatGPT. I'm gonna have ChatGPT change all of my titles and descriptions for the next month on my channel to target an international audience. What do you think, King? That's a good idea. What do you think? So if you see barrister, it means lawyer. If you see bloke, that means guy. if you see Lou, don't watch that stream. I use the word Lou in a title. Do not watch that stream. That's not an approach. Oh, I do have one. I do have one. He pees in a tent and gets arrested for it. That's coming up. So, bloke thinks tent is Lou, gets arrested. That's what our titles are going to be like soon. So, I don't think you guys even read the title. I don't care what the title is. I don't care what the description is. I don't care what the thumbnail is. It's my worst part about streaming is those three things. I hate it. I'll say Q. Absolutely. Dunny. What does Dunny mean? Does that mean bathroom? Sounds like it could mean bathroom. So, do I want to go with Lou for the UK or do I want to go with Dunny for Australia? Bogan thinks tent is Dunny. That sounds like I'll get a few. Moonshine. I love moonshine. Dunny. I'm going to use Dunny for the peeing in the tent. Which is, just classy on my part, I think. I mean, what? People in the United States, they're not going to click? Well, they don't already click. So, I think. Oh, in Ireland. Shannon, I need some Ireland. Now Linus is just taking it too far. No, he's not. Brasco. I like Dunny. I like it. I think that'll get a click or two. Get a click or two where the toilet spins backwards, maybe. Yeah, that's it. Dunny, because he pees in a tent and gets arrested for it. So he thinks tent is dunny. Americans will think I don't know how to spell, and I misspelled funny, but that's fine. You know, Americans are dumb. We are. I am. I didn't know what dunny meant till today. All right, guys. I'm not. You can show the Dutch toilet again. Only if you have a gold one. Yep, pub. All right, guys. You guys have a great day. I'll see you tomorrow morning. I'm going to make it an international title, so don't be shocked. Jax. You guys have too many freaking words for toilet, okay? I'm going to use dunny. Love you guys. Have a great day. See ya.
Yes.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in